Around 200,000 black Americans served in the Civil War, some in U.S. colored troop regiments and others in state units such as the 54th Massachusetts. Many did not come home. Those that did came home with their muskets and their hopes and quickly found both taken away.
Slavery was abolished by the 13th Amendment. When the southern states were defeated, however, they reenacted the slave codes. They called them the Black Codes. And under the Black Codes, you had the same punishments for keeping and bearing arms, basically 39 lashes with a whip. And you have the attempt by the southern states to enforce these Black Codes through the organized militias.
Once the freedmen and Union veterans were disarmed, they weren't protected against the reign of terror that followed, as masked men assassinated any who dared to speak out. Congress was outraged.
The 39th Congress met late 1865, early 1866, and again you see members of Congress decrying these slave code reenacted as Black Code provisions, specifically pointing out that it was inconsistent with the abolition of slavery that black people in the southern states were being disarmed. And you have repeated complaints about the behavior of the southern militia forces. They would break into the cabins of freed slaves, searching for arms, robbing them, and committing other outrages. At the same time, you have black organizations in the South organizing themselves and arguing that they have a right to keep and bear arms, they have a right to free speech and whatnot. And one of these conventions of blacks from which met in South Carolina was publicized by Senator Charles Sumner early in the 39th Congress. And he read off the rights of a freedman, and one of those rights was that the inhabitants, including the freedmen, the newly freed slaves, had a right to keep and bear arms. Now, how did the members of the 39th Congress, through legislation and the 14th Amendment, protect the right to keep and bear arms? In the first place, the Civil Rights Act, which was S-60, Senate Bill 60, Freedmen's Bureau Act, S-61, were proposed side by side, and they provided respectively as follows. The Civil Rights Act of 1866 was to apply in those areas where law and order was restored in the southern states and the courts were functioning. And part of that act provided that black people had the same rights as white people. The Freedmen's Bureau Act had similar language, and as part of that language, however, an explanatory clause was inserted as a floor amendment at one point in its legislative history, such that it read that the rights of person and property included the constitutional right to bear arms. And so there you had in the Freedmen's Bureau Bill a declaration that these rights of personal security and personal liberty included the constitutional right to bear arms. No other Bill of Rights freedom got that status in that legislation or any other legislation in the Reconstruction Congress.
But the Freedmen's Bureau Act was declared unconstitutional by lower courts. Nothing in the Constitution required the states to observe the Federal Bill of Rights or gave Congress power to force them to do so.
The Bill of Rights was written to constrain the federal government. The framers understood that states had their own state constitutions, most of which had their own state bills of rights, and that if a state was restricting your speech or searching you or restricting your gun ownership, that would be a matter to sue over in state court under the state constitution. In fact, quite a few right to bear arms cases throughout the 1800s were under the state constitution.
Congress responded by proposing what became the 14th Amendment, requiring states to observe the privileges and immunities of U.S. citizenship and also forbidding them to deprive persons of life, liberty, or property without due process of law. It then passed the Enforcement Act, making it illegal for anyone to deprive a person of their constitutional rights while acting under color of state law.
Looking at the debates at the time, it's fairly evident that both the detractors of the 14th Amendment and its advocates considered the impact of the 14th Amendment to be to grant to essentially freed slaves the privileges and immunities of American citizens. That includes the Second Amendment and all the provisions of the Bill of Rights. And it was deemed to be quite controversial at the time. Was some of the best evidence that we have suggesting that the Privileges and Immunities Clause was intended to extend the Bill of Rights to freed slaves is the controversy between the advocates and the detractors of the 14th Amendment regarding whether it was good policy or not to have the freemen with access to not only the right to assemble peaceably and things that were granted under the First Amendment, but also the right to keep and bear arms wherever they went.